in this hour, there couldn't be any bigger headline than Hunter Biden, yes, the 54-year-old son of Joe Biden, who was convicted today in a Delaware courthouse. We're going to bring you the latest in terms of what that conviction means, how the jury got to the conviction, and why wasn't there what we call in the legal business jury nullification. I was on TV 2 nights ago and I said, well, I think there's going to be an acquittal. I think this jury is going to reject this claim because the law seems to be being used in a way to prosecute Hunter Biden that wouldn't happen if his name wasn't Biden. Boy, was I wrong. And when I'm wrong, I'm the first to admit it. I had faith in that Delaware jury that they would see through this, what I believe to be a political prosecution of Hunter Biden, and return an acquittal, not because necessarily the evidence didn't support the claims made by the prosecution, but because fairness dictated that Hunter Biden not be singled out and charged for a case that the former head of the department that's prosecuting him said would have never, ever been brought. The former head of this department says, we didn't file cases against people who made false statements on these applications if that person was not a convicted felon at the time the statement was made, and if there was not a commission of a crime, i.e., if the gun that was purchased wasn't used in a crime. He says, we didn't pursue these cases because we would not have any room to pursue very serious crimes if we literally, charged every case that was brought to our office. So we're going to talk about jury nullification and why this jury made Areva wrong by convicting Hunter Biden. Also in this hour, we're going to talk about Mark Ridley Thomas, former LA City Council member, former LA supervisor, county supervisor, filed a very important document in court yesterday. He filed his reply brief to the appeal that he initially filed a couple months ago. The prosecuting attorneys, the U.S. Attorney's Office, filed a lengthy opposition to his appeal. And some experts say that the prosecution has switched its theory. So I'm going to be asking my legal experts, does that mean they've lost faith in their own case? And can you do that? Can you bring a case, base it on a theory, present evidence on that theory, and then get to the appeals process and say, well, I don't know, we don't think that theory works on appeal, so we're going to switch the theory. I have the perfect legal experts joining me, our regular contributors, Bobby Grace and Mansfield Collins are here to help us make sense of all of this breaking legal news. All right, welcome back to the show, guys. Let's start with the biggest headline. A jury in Wilmington, Delaware, proved me wrong, Mansfield. I predicted that there would be jury nullification, that Hunter Biden would not be found guilty on these 3 felony counts of lying on a federal firearms application in 2018, although the evidence presented by the prosecution, I must admit, was pretty compelling. Tell us what you think happened with this jury and explain to us what jury nullification is and why you think it didn't happen in this case.
Jury nullification is the idea that you don't want the jury to actually focus on the actual charge facing the defendant. You really want to focus on the process and the other factors that contributed to the filing of the charge, and therefore ignore the evidence that the prosecution is going to submit and use your gut and use your intuition and vote your intuition, not the evidence. I think the defense made a mistake by showing the jury that this was a so-called accordion theory. My pages and my picture isn't big enough to do it. The accordion defense. And what he meant by that was, yes, the government had all of this evidence, the size of an accordion, and then he tried to shrink it down and said, but if you just look at just that 1 second when he signed that application, that's the only thing that you have to focus on. Unfortunately, jurors all the time are told, when you walk into the courtroom, you do not leave your common sense at the courthouse door.
Okay, so Bobby, Mansfield says they made a mistake with this accordion theory. What do you think a more persuasive theory by the defense would have been, given that you got 3 women who were as close to Hunter as anyone could be, talking about his pervasive drug use during this period, not necessarily on that day, as Mansfield said, but during the critical period? What could the defense have done differently?
Well, probably a better defense, Areva, would be to try to argue that the statements that were made were not materially false. In other words, they were errors of commission, omission as opposed to commission, and that it possibly were influenced by the fact that he was addicted, and probably tried to play that aspect of it more, like say that, he might not have been taking drugs at this specific time, but let's say he was taking drugs within a certain period of time leading up to him making the statements that he made, which would have influenced not only his willingness to make the attempt to get the gun, but also may have influenced his judgment with respect to putting in what was later, that's jury determined to be false statements.
But it sounds like you're saying intent. Like he may have, yes, acknowledged that he may have made the statement, but he didn't intend to lie or to mislead. But this isn't an intent crime, is it, Mansfield? They didn't have to prove intent, they being the prosecution.
It's just a willful conduct crime. And that's what they used a lot of evidence to convict him with. But, you know, when you really look at the jury nullification, you could argue in this case that the prosecution's overloading of all of that information from all of the women in his lives, especially when I guess it was his former wife or girlfriend that testified that she wasn't a crack addict until she started doing crack with him. I mean, that was the former wife. It was so prejudicial in a sense. There was so much prejudicial information that was used by the prosecution. I'm wondering, everyone, if they actually have a good case for appeal.
Well, I think there's an excellent case for appeal because the day before this indictment, a 3-judge panel on the Fifth Circuit determined that the statute is so ambiguous because the statute references controlled substance, the unlawful use of a controlled substance. So codeine is a controlled substance. So if I'm at my friend's house and I have a backache because I threw my back out and she has codeine pills and I take a codeine pill, that's a controlled substance and it's arguably unlawful because it wasn't prescribed for me. And I fill out that form and say, no, I've not taken a unlawful controlled substance. I arguably could be prosecuted under that statute. And the Fifth Circuit said that's too broad, it's too ambiguous. And they refused to uphold a conviction of someone using marijuana in a case involving this language. And we know pending before the Supreme Court is the case about people who have committed domestic violence. Are they allowed to use guns? So we have all this stuff swirling around where Republicans have been pushing for an expansion of who can have access to guns, including people who have mental health issues, including people who've committed domestic violence, and including people who smoke marijuana. Yet you have this pressure on the prosecution to prosecute Hunter Biden in this case of someone who clearly was addicted at some point in his life, had a substance abuse issue. He's now clean, had the gun for 11 days and didn't use it to commit any kind of crime. It was thrown away by this ex-wife. So I think the appeals opportunities are vast and likely, again, if it's not, we hate Joe Biden kind of appeal judge, he should win on appeal. But I want to go back to my jury nullification, Bobby. The problem with that is, as the defense lawyer, you don't get up and argue that you want the jury to nullify. You don't get up and say, throw out all the evidence that's been presented, and you have an opportunity to disregard the facts and the law. So that makes it a little complicated for defense lawyers.
No, and they wouldn't want to be put in a position where they were arguing jury nullification, because that brushes right up against the line against attorney misconduct too.
Right.
You have a right to zealously represent your client, but you don't have a right to argue that the juror should avoid doing their duty in court. You can't ignore juror rules. And so they would never have done that. But I do think you're right, Areva, that jury nullification was something very real here that the prosecutors had to think that might happen. And reading the comments from the different jurors, they all seem to say that they were very focused on trying to follow the law. regardless of who the person was that was being charged with the crime. And they all admitted that they knew that he was the son of the president, but they felt they had a responsibility to follow the law.
Mansfield, let's talk about this 25 years in prison. All the media keeps leading with this. Unless, again, it's I hate Joe Biden judge. There's no way that this conviction leads to 25 years in prison. What do you predict the likely sentence to be for this conviction?
I'm going to go way out on the limb on this one, and I'm going to say that I think that he's not going to get any prison time. I think there'll be a substantial deviation so low from the sentencing guidelines that he's going to end up in the probation house arrest category. And for all the reasons that we have been discussing so far about this particular case. By the way, the Republicans believe that that form that he signed is unconstitutional. They don't even want the form. They want to outlaw the form that says you have to, were you intoxicated or were you using drugs at the time you purchased this gun? So I think he has a breadth of grounds for appeal, and he's going to find strange bedfellows supporting that appeal, Republicans.
Absolutely. Bobby, what do you think about it? I'm with you, Mansfield, on the probation. He's going to come in incredibly remorseful. He's sober and clean. He's got all kinds of mitigation. The mitigation is going to be expansive. What do you think, Bobby? You think he serves 6 months, 12 months, or house arrest?
He should do house arrest. The only way he would do any substantial time would be because the judge is trying to make a political statement out of this, where there's really no statement to make. This is not connected in any way to the activities of his father as president. And, any other person in the same position would get probation. And so I think that that's what will happen here.
Yeah, it just burns me up that the media keeps leading with this 25 years in prison, and knowing, and they know, they have lawyers that work for them, so they know that's not even a remote possibility. But it's a headline, and it gets people's attention. I've had people ask me, is he going to serve 25 years in prison? No. The answer is categorically no, again, unless there's some judge trying to make a huge political statement. But again, even I think deviating from what others who have been charged with this, with his background, would set him up for a very successful appeal. But he's not out of legal jeopardy. He is facing more serious charges around tax evasion. That case is a little, I think, probably scarier, or should be scarier for him even than this case, and could again cause him to be convicted, and there is serious jail time associated with the charges in that case. So when we come forward, we're going to talk about this other trial that's going to kick off in September that Hunter Biden faces around the taxes or non-payment of taxes, according to allegations made by prosecutors. And also we're going to talk about Mark Ridley Thomas. He filed a reply brief to the U.S. Attorney's opposition to his appeal in his federal bribery case. He made substantial arguments, and some legal experts are saying that the U.S. Attorney's Office has switched its theory, that it's no longer relying on the theory presented at trial that wanted the conviction to move forward with this appeal. I'll talk to our legal experts about, is that legal? Can you really do that on appeal? We have been the station across California that have brought you up-to-date coverage on the case involving LA City Council member and LA County Supervisor Mark Ridley Thomas, one of the most prominent African-American elected officials in this state, who was convicted on federal bribery charges this year. He filed a sweeping appeal saying that the charges should be basically, the guilty verdict should be thrown out. The U.S. Attorney's Office filed an opposition, and some legal experts say that the opposition switches theories, that the prosecution presented one theory during the trial and that its opposition brief switches theories. And yesterday, Monday, Mark Ridley Thomas's team filed its reply brief. We're still waiting to see if the Ninth Circuit Court of Appeals will accept the appeal and set an actual hearing date so that the lawyers can go in and present oral arguments. But this is a substantial development in this case that we have been covering gavel to gavel. Mansfield, bring us up to speed. Address this issue by some experts that the prosecution has now switched its theory. One, tell us what the new theory is, and two, tell us, can you do that? Because I don't think that's so intuitive that you can present a whole case, spend weeks in trial, and then get to the appeal and say, well, I don't know, if that theory doesn't sound good, Your Honors, here's another one. What's happening?
Well, remember during our broadcast of the Mark Ridley Thomas trial and then the conviction, and how shocked we were with the conviction, and then Mark Ridley Thomas filed his appeal, and we were completely ecstatic that the appeal raised obvious, clear grounds for reversing the conviction. And when you read the reply brief to the government's response to that appellate brief, all I can say is I would almost bet my house. Now, I'm not going to bet my house, but I believe more so today that Mark Ridley Thomas's conviction is going to be overturned. And it goes back to some of the comments we had live on the radio. The government kept using, I would say, charged words, funneling, the king of a monopoly in Los Angeles. Those kinds of terms distract the jury, pull the jury away from actually using their head to look at the true evidence. The government's approach was to go to the heart. And when you try to sell a case based on the heart, you stand the risk of having a bad result, a bad conviction. And that's what happened in this case. So the government used funneling. And now they realize there is no crime of funneling. Funneling is just a pass through. I mean, it's not a crime. And when you look for the incidents of the crime that funneling is supposed to be identified with, there's no quid pro quo. And it looks as if, when you really look at it today, it was really just a thank you from USC for all of Mark's support in the past. And a gratuity, a thank you, is not a crime, because people extend thank yous for past services, not future services, all the time. So I believe that this case is going to be overturned for a lot of other reasons as well.
So take us back, Bobby. Mansfield is mentioning this term funneling. The original theory was not that the crime was funneling money from an account that Mark Ridley Thomas controlled, a donation made to the university that then was directed to a nonprofit that his son operated. There was a witness that testified on behalf of the defense that the donation that Mark Ridley Thomas made of funds to USC, and then those funds being directed to that nonprofit, that was not illegal. But that wasn't the government's original theory. So talk to us about what the original theory of the government was as to what constituted bribery.
Well, what the original quid pro quo was, or if you remember, was that Mark Ridley Thomas was engaging with USC and saying that I'll do this for this. So if you do this pass through, which would benefit my son ostensibly, I will do this with respect to this telehealth contract that was before.
And this was, I will sign off on, I'll vote in favor of a contract for the School of Social Work that will result in thousands of dollars of revenue flowing into the School of Social Work, right?
Exactly. And the problem with that was that when it all came out and the smoke cleared, that was an ongoing contract that was going on with the Board of Supervisors that they really didn't have any new information, new vote on. It was just going to be a cursory vote to continue a contract that the Board of Supervisors had already negotiated with USC. So now the government is faced with the issue, okay.
Well, hold on, let's stop right there, Bobby. They're also one of the issues we learned, like you said, when the smoke cleared. Remember, let's go way back to the LA Times breaking of this salacious story. $8 million, right? That was what was reported out. $8 million in contracts given to the USC School of Social Work in exchange for Mark Ridley Thomas's son, Sebastian, getting a scholarship to the School of Social Work, getting a job at USC, getting this donation to his nonprofit. So the headlines sounded horrible. Like Mark Ridley Thomas is giving away $8 million of public funding so that he could get his son in this cushy position, because his son is being accused of sexual harassment in Sacramento, where he was serving as a state legislature, and he's going to resign from there, and they need a soft landing. And Mark Ridley Thomas didn't want any harm to his reputation because he was a prominent elected official, possibly thinking of running for mayor. So let's give $8 million to USC, get the son a soft landing as a professor, as a student, give him a scholarship, and set him up in this nonprofit. That was the story we were told initially.
And you remember, Areva, that those allegations all stemmed from the dean of social work at USC putting what she thought could happen in the future, but Mark Ridley Thomas never agreed to that. And the board of supervisors were never presented with any contract that even talked about anything like that. And to go even further, none of the information about Mark Ridley Thomas's son ever came to light with respect to, the major issues in the case. So,
in fact, he was acquitted on all of the charges that had anything to do with his son.
Exactly.
So those counts were thrown out by the jury. And Let's be real clear. There was never, ever any evidence by the prosecution of an $8 million contract or $8 million being directed to the School of Social Work. There were a couple of contracts, one or two, I can't remember exactly. But as you said, one, the money left, if any, on the contract was de minimis in relationship to this alleged $8 million. And there was never an actual vote. It was a cursory approval of these contracts that's done routinely. So it wasn't Mark Ridley Thomas walking into the board of supervisors, making some impassioned speech about why money should go to USC and raising his hand saying, I vote for USC to get this big contract. And
we knew, Areva, that they had
the way the case was presented.
And they had to shift gears because they weren't able to sustain any of that in their case in chief. And so they had to shift gears. And we kind of knew that we'll be talking about this, but we knew that they were going to have to shift gears with respect to theory because they previewed that in their reply with the motion for new trial. So we've kind of seen where they were going with all of this and gotten a preview of where they had to go.
So conviction. So the $8 million never materialized. No witnesses ever called by the prosecution from the county of Los Angeles. No witnesses called from Mark Ridley Thomas's office. No one really that knew what the county was doing, that could explain the county process, that could explain these contracts. All witnesses from USC and other what the prosecution believed to be favorable witnesses. But on the basis of what they presented, they get a conviction. And now there's an appeal of that. And the appellate team, the A team, some of the best appellate lawyers in the state of California are representing Mark Ridley Thomas. And they point out to the court, Your Honor, there was never any quid pro quo, meaning the prosecution never presented or proved to the jury that Mark Ridley Thomas gave the university something, and in exchange, they gave favor to his son. So thus comes, okay, then if you can't prove that exchange, which is your typical exchange in a bribery case, what do you have? So now we get to the funneling. When we come forward, we'll talk about what the new theory is of the prosecution and what are the chances of that likely being persuasive to an appellate court. All right, Mansfield, we don't think, the three of us, and I think we're pretty smart lawyers, don't think Hunter Biden is going to serve any time conviction in this case that he was found guilty 3 counts online on an application to purchase a gun. But he's facing some pretty serious charges in September. Talk to us about these charges related to tax evasion and how serious are these charges?
The tax evasion charges are very serious, and it's the easiest white-collar crime for the government to prove, because all they do is hold up the signature section of a tax return. They say, did you sign this? Is this your signature? And even if you ask your tax preparer to sign it for you, did you ask your tax preparer to file this tax return for you? It's an easy case. However, if you think about what happened in this case, the underlying gun charge case, where the government spent, and a special prosecutor, not the government, but a special prosecutor, he spent so much time throwing mud on the fact that Hunter Biden was addicted to crack cocaine. Well, that may be one of the defenses to, yeah, I didn't know what I was signing, and could be a defense in the tax case. If he is truly a crack addict at all times, I'm wondering if he's a crack addict during the time that his tax returns were being prepared and filed. But generally speaking, tax evasion cases end up in plea agreements. They don't go to trial.
And Bobby, I was getting ready to say, people do go to jail for tax evasion. Unlike this line on an application to buy a gun that gets thrown in a trash can 11 days later. Is it your sense that, or your belief that if he does get convicted, if there is a trial on these tax charges, he literally could go to jail? I'm thinking about Wesley Snipes.
Yeah, that's different.
Serious jeopardy of going to prison for this. And because there wouldn't want to be a situation here where he were to be convicted and then people hold up this as an example of the privileged who got away, didn't get jail time when other people, Joe Blows, whatever, got serious jail time for not doing taxes. And you brought up Wesley Snipes. There have been a number of other individuals, some who I think of Joe Lewis back in the day, had many tax problems. He didn't go to prison, but there have been other people who tried to evade taxes on purpose, which it appears that the government's going to be able to prove that he consciously tried to avoid paying taxes, and that generally ends you up in prison.
Yeah, there have been a bunch of reality stars that have recently gone to jail over tax evasion. So, those charges are scarier. And you said Mansfield, a plea deal. I wouldn't imagine that, given the pressure and the eyes on this case, that there would be a plea deal that wouldn't involve some jail time. Could you imagine a plea deal that didn't involve jail time? They tried that, and the judge blew it up.
Yeah, I could imagine a plea deal that could involve a combination of minimum moderate confinement. Maybe, for example, if I just say there's a Lompoc federal facility in California, and other states have similar facilities. It's one of the better, safer, nicer facilities. If you look at federal penitentiaries in that light, he could probably get a sentence of maybe 8 months in Lompoc and then 6 months on house arrest, a split sentence. Something like that would probably be fair to the public and fair to anyone that had a tax problem, because there is a perception that he's being picked on by the Republicans. There is that clear perception that if anybody has a claim for being persecuted because of his political affiliation and his last name, he certainly would have that.
Well, clearly, any arguments that Donald Trump continues to make about the justice system being weaponized against him, or that the justice system has somehow been corrupted by Democrats, that goes out the window when you have the president's son convicted and the president himself saying he will not pardon Hunter Biden. Let's put that on the record as well. He said he will not pardon his son. So there is no weaponization of our judicial system. We just, people who are privileged and people in high profile positions often do things that land them in court as well. Before I let you go, Bobby, let's go back to Mark Ridley Thomas, though. This funneling. So now the prosecution abandons this theory that there was this quid pro quo because they never produced the $8 million. They never produced any contracts that had any value. So they couldn't say he was trading money to get favor for his son, because there was no money. There were no contracts of value. So now they're saying, well, he funneled money from his campaign account through USC to his son's nonprofit. And the jurors, I think they talked to one of the jurors in one of these news articles, and she said that was concerning to them, that in their mind made him guilty as well. Can prosecution, you've been a prosecutor for more than 20 years, can you change theories like that on appeal? Is that allowed?
What you can do is point out to the judge that an individual was charged with certain crimes and that the facts or the evidence that were proven in court fit, parts of the crime that he was charged with. It's disingenuous and is frowned upon and could lead, as Mansfield has brought up, to even more avenues for appeal if that's really the route that they're trying to take. We know that usually when we talk about felony, it's usually money laundering in terms of drugs, et cetera, et cetera. In California, it's legal for charities to use pass-throughs. And this was what apparently Mark Ridley Thomas knew what the law was and was using the law in California to his advantage. It seems, unfair that they would try to, spin it as a federal crime when it's not a California crime.
Well, we know that it was legal because he had an expert witness testify that the transfer of the funds from his campaign account to USC and then to the nonprofit in question was in fact legal. There was never any evidence to the contrary. No expert on the part of the prosecution to say that was an illegal transaction. All right, Mansfield, all the papers have been filed. What next in this case?
Oh, I think the conviction is going to be overturned. And remember, there's one thing that really stands out about this case that every other case does have. This case was documented. Whatever the transaction was, it was documented on USC side and it was documented on Mark Ridley's side. In other words, there was no secret. There was no deception. There was no corruption. When you think about quid pro quo and fraud and bribery, what's the purpose of the fraud and bribery? To hide it from everybody. You can't hide anything from USC and their record keeping. And that was never the intent. So no, I think, and then the 12, the jury verdicts were mixed, 12 not guilties and 7 guilties. It's clear that they were confused. So I still support very strongly that this conviction is going to be overturned, and it should be.
Real quickly, Bobby, will there be a hearing set? And if so, when?
I think there will be a hearing. I think the hearing will be set sometime in the fall, late fall, maybe past the election, but before the end of the year. And Mansfield and I were discussing, there's some cases that have just came down that are before the Supreme Court around honest services. And so there's tremendous opportunities here for appeal, a lot of avenues. I think there's fertile ground here for Mark Ridley Thomas's team.
The government went too far.
Well, and we've seen that on numerous occasions, and this happens to be, in our opinion, to be one of those occasions. Well, thank you so much, Mansfield. Thank you so much, Bobby. We're always a lot smarter when we spend time with both of you. We'll continue to keep you posted on all of the developments on Mark Ridley Thomas's case, and I'll have this expert panel back as we get more breaking legal news.